very exciting session on digital content, intellectual property, and innovation. We have a very distinguished panel. It's a big panel, and all the names and bios are on the website, and you know most of them by sight anyway, so I will not spend much time introducing each one of them. I will pass on immediately to the moderator, Wolfgang Kleinwächter, a professor at the University of Aarhus. He has followed the Information Society discussions on internet governance for many years and published extensively, and I'm sure he will lead a very animated discussion. Please, Wolfgang, over to you.
Thank you, Markus. Good morning, everybody. And I hope we have a very interesting, very interactive discussion the coming 2.5 hours. I also signal in the beginning we will have somewhere in between a coffee break. So that means don't be afraid. So we will have a little bit time to also to relax and to have then bilateral consultations. But let's start going straight to the issue. I think the intellectual property issue is one of the most controversial and also most complex issue which has raised in the public policy debate around the internet in the last couple of years. And we have a broad range of arguments with extreme positions on both sides of the spectrum. And our aim here is not to repeat this traditional battle between the two sides, but to look forward and to find probably some constructive answers, how we can bridge the various positions and to come out with something new. On the one hand, we all understand that there is an established regulatory framework, which has to be respected. On the other hand, we see there are new technologies which partly undermine the existing framework or offers, more or other alternative opportunities. So, and this has to be brought now together. That means we have to look for a solution, a mechanism, a business model which fits into the new technical environment. I think this is the challenge, and all sides have to look how to do this. Before I prepared myself for this session here, I went back to the history and to the first international convention, which was the Bern Convention from 1886. And I was looking, what was the motivation behind this treaty, why governments had this treaty. And there were two main things. So they wanted to give an incentive for intellectual production, and they wanted to protect works, in particular Victor Hugo, who was the author from France, who was very upset that he did not get any money from the United Kingdom. His works were protected only in France. So, and he said, I have a lot of readers also in the United Kingdom, and so that was the driving force behind the Bern Convention. A very, very clear arguments. And when the same issue was discussed in the World Summit on the Information Society, and Janis was the president of Phase 2, we came out with two paragraphs in the Geneva Declaration. One says, the protection of intellectual property is important for creativity. And the other paragraph says free access to knowledge is important for creativity. So that means over the years we have always, these two arguments, and now confronted with this new technology, we have to find a way forward. So let me start with a concrete question to Vint Cerf. He had a special situation in the year 1974 because he invented something, the TCP/IP protocol, together with Bob Kahn. And 2 years ago, Vint Cerf visited Australia and was asked by Computer World about, Mr. Cerf, did you expect that the internet will be so big as it is today? And this is what Vint Cerf said in the year 2010, in February 2010. The question was, this is now Vint Cerf, would it be something that could be rolled out to the rest of the world? We didn't know for sure, but when we worked on it, we decided not to patent, not to copyright, not to control, but to share everything we knew about the internet design to the general public all around the world. What would have happened, Mr. Cerf, when you would have it patented or copyrighted? Would this internet be as it is today?
Well, I might be a lot richer than I am. In fact, no. I don't think the internet would have happened at all, and certainly not in the way that it has evolved. This open access to the information about its design and how it's implemented was absolutely fundamental for several reasons, not the least of which is that adoption of those protocols, I think, would have been inhibited by any excuse to not license something which had been patented, or to, if we had even tried to copyright all of the specifications, someone would say, well, we're not interested in trying to get access to that copyright material under whatever conditions we would imply. I think that this only worked because everything was freely available. And what this teaches me is that there is some information which does not necessarily have to fall under the conventional copyright regime. And in fact, there's some information that does not have to fall into the two categories which are common, copyright and public domain. And it is the Creative Commons idea that Larry Lessig pursued that said there's a spectrum of utility in control or non-control and access or controlled access for all kinds of information. And we need to take that into account as we think about intellectual property. We need to give the creators of it a much broader range of options for the management of and access to what they create.
Thank you, Vint. By the way, any reaction to what Vint have said? Professor Heuer, you are the Director General of CERN, where Tim Berners-Lee invented the World Wide Web, and he was probably in a similar situation than Vint and Bob in the year '74. And Tim Berners-Lee just recently, also, made a statement in Wire, where he said, to the issue we have today on the table, record labels have a very strong voice when it comes to arguing for their particular business model, which is in fact out of date. So, who will win, technology or the traditional regulation, or what could be the third solution?
Well, first of all, I think I would fully support the words of Vint Cerf, because with one small difference, that I would not be richer, but CERN would have more money to to do its science. On the other hand, it would not have as much money as people think or would expect, because I think the web would have developed completely different. We would not have one web, we would have several webs. Yeah? All the different webs protected by IP, no cross connection or difficult cross connection. So I think the world would look completely different to that, not only on the money business. What is the solution? I think it's very important to keep a sort of control of what's being done. That means, what is, if I understand correctly, the copyleft philosophy, that you give it for free, but the others who take it and modify it also have to give it for free afterwards. Yeah, I think that's very important. But that only works once you are not having to derive your income from it. And I think this is the catch between the two things. So I think one has to find different solutions for different aspects. If you take the scientific aspect, I think everything should be free. Free access, open access. However, if you go, as you said, to the music industry or so, then it's different. I mean, these guys have to take their income from it. So one has to make sure that they get something.
When want to respond, and then I want to ask David a question.
So, just an observation about the free and income. Linux might be an interesting example because that's an open source environment. There are companies like Red Hat which do make money from this by catering to and supporting and helping people who use those open source systems. So there may be ancillary ways of generating revenue not precisely by selling the product, but its service and support for it.
Yeah, you are right, and I think the same applies now to the new move of open hardware. It's not only open software. Now we are even going into an open hardware, and it's to me a miracle that this seems to work. Yeah, so there must be a way in between, which I personally, I must admit, haven't understood yet.
It's the Higgs boson is doing it, I'm sure.
So
I'm not sure.
we see already, it gets very, very diversified, and there will be no single solution. Right. David from the Radio Industry Association of America, RIAA, is always, very strongly fighting for the rights of the music industry. Right. And what is your approach to this business model? Is there a chance to have a third solution, or do you disagree or agree with Tim Berners-Lee when he said the existing model is out of date?
Yeah, I don't, and I spoke with Tim yesterday for 90 minutes on this topic. But I should say that I am a technologist, but I've spent my whole career in the music industry, spent most of it at Sony Music. And I think that there are different kinds of information. Rolf just touched on this. Information and knowledge and artistic creation, or even just entertainment content, they're not the same. And I'm a big fan of Creative Commons. In fact, we use it quite a lot. Our music industry data standards, DDEX and GRID, we use the Creative Commons license for these. But I think Creative Commons is not necessarily applicable, as Rolf said, to professional content creators. Because music does not equate to software and technology development. I just don't, and I think that this is what has happened, is that people who have seen, and as Tim Berners-Lee has said, if we had had patents, we wouldn't have the web technology, and I believe that this IP can be a stumbling block, but especially in the entertainment and artistic creation area, intellectual property was set up to encourage innovation, and the lack of remuneration to content creators makes them unable to be professional content creators. You cannot spend your 10 or 20,000 hours honing your craft and then spend a year working on an album if you're working 50 hours a week at a job.
Thank you, David. Martyn is one of the creators, and we had yesterday an interesting discussion where he had his very personal perspective as a creator. What is your comment to David's statement?
Well, it's quite interesting. We come from the same profession, and I've been a producer and an artist for 35 years, created lots of content, sold 50 million records. So in theory, I should be completely on the same side as David. In fact, I just think that if we were inventing this system from scratch now, I think it's completely not fit for purpose. This is my contention. I think it's a very easy thing, facile thing to say, but I think we need to look at the reality of the situation. For every one piece of work that is sold via a traditional method of my copyright, there are probably 99 so-called illegal copies being distributed and copied. I don't think you can actually have the right to copy anymore and sell that. I believe if we're looking forward, which I believe we need to, rather than trying to just shoehorn the new technology into this old model, I think we need to find a way to compensate artists in a different way. And I know that I've just been writing down what the pluses are of the internet for artists. And I'm going better research, more inspiration, faster distribution, free access, and we can make money from spin-off activities like playing live. And I know, as a creator, I make more money out of playing live than I do out of distributing what we would call my copyright now. The minuses: how do artists get compensated? We have to talk about this. I don't know what the answers are, but I know that the current system isn't working for artists. But the key thing is, how do artists drive traffic? I mean, I've just recorded an album with a lot of famous singers, that I can't get a traditional record company to release in any significant way and agree to market properly because sales are so low. I want people to think about the real world, not the theoretical world of lawyers and copyright agreements and treaties, but to think about, I'm here to represent these artists, to the people who don't get to speak in fantastic places like this and don't have lobbying capabilities and don't get to talk to commissioners for the European Parliament, which I have been very fortunate to do. I spoke to a vice commissioner of the European Parliament who said in 25 years he'd never met an artist, which is incredible. And I think, you know, there's a lot that, I mean, I'm not saying I'm representing everyone here. My views are probably slightly left of centre for a lot of artists. But I believe that we have to acknowledge the reality of the situation and that we have to move forward and try and find a way that the average creator and artist can actually be compensated for their work.
Thank you, Sacha. How many artists are going every day to the World Intellectual Property Organization and giving their views in the negotiations you have to manage all the treaties which are under your control? And what is the discussion in the WIPO now with these new business models?
Right, thank you. Well, one of the advantages of moving from Paris OECD to WIPO, for me particularly, was to be in closer touch with creators and artists. So there's days when you walk into WIPO and there's a Maasai warrior, you know, representing his interests. So I was quite impressed by the participation of civil society in the meetings. I mean, WIPO has been undergoing, under the leadership of Francis Gehry, quite some changes also in the way, you know, the reflection is ongoing on copyright matters, you know, copyright infrastructure. And I think he will be addressing this audience himself later today. And I just want to react a little bit to these alternative business models versus traditional business models. I don't really think that this opposition holds in reality because, I mean, nobody's trying traditional business models still, right? I mean, just everybody is moving to trying to adapt these traditional publishing industry models to what I call like the digital ecosystem or, you know, new broadband value chains. Now, if you look at these markets, they are developing extremely fast, but from a low level, right? I mean, I think in music, what is it now, David? It's about 50% maybe in the US, 30% sold online, right? But if you look at other sectors such as book publishing or films in particular, it's still excruciatingly small, right? The level of online sales. And what I, just as an economist, I mean, I see this as a huge potential, right, that the internet offers for a perfect market, you know, people interacting directly with artists, remunerating them directly, you know, the artists having a bigger share of the pie potentially, you know, publishing industries blossoming and everybody profiting. Now, in reality, what we face today is still a pretty small share of online versus offline in most industries. And what I am fearful a little bit of is these content, what I call content enclaves, which are forming, right? We have all this content available on this platform, then on this platform. And I mean, if you honestly, I mean, I tried it out on Sunday night. If you try to get a blockbuster video on a Sunday night in a legally paid manner, it's still in Switzerland, still pretty difficult, right? You know, so I think that there's a lot of leeway here to perfect these online business models. And I think what we have to stay away from is these digital content enclaves. The fact is that today, content publishers have to enter into negotiation with a lot of other players, right, in this digital ecosystem, intermediaries, payment methods, and etc. And this has to play out in a more fruitful way over the next years. As an economist, second point and last point, what I find extremely difficult is a lot of people talk about you know, the internet facilitating other forms of content creation, user-created content, middle-class musicians reaching out to the audience in new ways. You know, that money is actually being made by Google or Apple, etc., and not maybe by the publishers. We don't have a lot of data on this, to be honest, right? There's a lot of speculation. 10 years ago, everybody thought that artists will sell their music to, you know, directly to users, and this will be a perfect symbiosis. This hasn't happened, obviously, in such a way. There's a new ecosystem, but we have little data on how is the revenue shared between these players, and most of these players are not really forthcoming with sharing that data. You know, I tried in a music study, this was in 2004, to show what the share of money going to artists from a CD, offline CD, versus share going to artists from an online sales. You know, I had to do some undercover CIA work almost to kind of get to these sort of shares. And I think this shouldn't be the case, right? We have to, for this discussion to be more fruitful, we need a bit of more data on these new business models.
The question of transparency will certainly pop up in the discussion a little bit later. You know, how we get more transparency in the whole chain so that people understand it better and then also, you know, accept, for instance, paying for something. If they know, you know, it's a good product and I have to pay a good price for it, and people are ready to pay for it. The question is, you know, if this is acceptable, reasonable priced, and all these things. So I think the user certainly plays a critical role. And you said already civil society is active in the WIPO, so it wasn't the case 10 years ago. Welcome to the club of multi-stakeholder organizations. Robin, you know, you represent a strong civil society organization. What is your reflection on the discussion so far?
Thank you. Yeah, I think it's worth underscoring that all of us want artists to be paid. All of us want a world where there is lots and lots of music and artists are able to live from producing their craft. So I think that it's worth saying that we want artists to be paid. The question is, how do we get there, given the incongruency between the existing copyright model and traditional business models and the new information age digital world that we live in? It's important to remember that copyright was originally invented at a time when it was really difficult to move things around, to move music and books around in the world. You had to put it down on paper and ship it off to another country if you actually wanted to get it there. That was hard. That required a certain need to create an incentive in the copyright model. So that made sense in that world. But now we've moved into a new world, the information age, the internet age, and I think we have to look at new business models that harness the properties of the internet rather than trying to fight against those properties, meaning like the ease of copying and the ease of distribution. These are the properties of the internet, and we see traditional business models really trying to fight against those when I think they should turn it around and harness those properties, because that's where the future is headed. So business models perhaps where things feel free but aren't actually free would be an example. Just take, for example, over-the-air television. It feels free because you don't put in a quarter every time you want to watch a TV show, yet all the producers and the actors and such are in fact paid through a different type of business model. So I think if we just kind of can look to the properties that the internet has and try to harness those properties with the business models rather than fighting against them, because it's a losing effort to try to fight against the ease of copying and distribution that the internet offers. Thank you.
Okay. Yeah, I think one of the problems is indeed that our regulation and also the business model are coming from a time where we had clear control territories. So, and it was linked to a territory, and then we managed, you know, cross-border issues in a separate way. This is gone with the borderless internet. I will ask Leslie in a minute about, you know, options, you know, how to manage this conflict. But before that, I wanted to ask Jānis Karklinš, the Assistant Director General from UNESCO, because it's much older than WIPO, and you are dealing with these issues, you know, for many, many years. What is the UNESCO's role now in this global debate?
No, actually, UNESCO went out from the debate on copyright protection and passed it on fully to WIPO. But I would like to raise maybe a little bit different aspect. Even here we're thinking in terms of existing systems or existing possibilities. But when we, I think, resolve this issue, we need to think completely out of the box. We need to go back to the beginning of the internet, and which is, in a sense, has created this problem we're facing today. And I'm referring to a perception that everything is free on the internet. And actually, we're very accustomed to pay access to internet, and we are not prepared to pay for the content. And I think that this is something which we need to change, because content is not free. Only cheese in the mousetrap is free. So content is not free, and we need to acknowledge and accept that we need to pay for the content. So how to do it? And this is the way how we need to approach this issue, and think completely out of the box, and think whether this perceived gratuity or free of charge internet is the way how we can really address issues we're talking about.
Thank you. You know, money is still collected mainly on a national level, Leslie. So, but we have this global world. So, how you can get then, you know, if you have to pay for it on Tuvalu, you know, how to get the money to another place.
Could I ask a question? Jānis, not everything necessarily has to be paid for. Some people are willing to share their information without compensation. So I hope that your assertion is not intended to be universal.
Maybe if I can come in on this one as well, Wolfgang, just for a little bit. There is no free, I mean, you know, I think it's an illusion to believe that there's free versus paid for. When you access free content, you have already paid your broadband subscription, you just got yourself a pretty nice smartphone, et cetera, right? So it's not exactly as easy as that, right? So the revenue might have shifted in the value chain a little bit, but you don't, I mean, it's not like you just pick it up on tree, right? I mean, you pay for other services that get you the access and the hardware, the infrastructure. I think the important thing is how to distribute that, you know, that revenue more properly.
That we want artists to be paid. The question is, how do we get there, given the incongruency between the existing copyright model and the traditional business models and the new information age digital world that we live in? It's important to remember that copyright was originally invented at a time when it was really difficult to move things around, to move music and books around in the world. You had to put it down on paper and ship it off to another country if you actually wanted to get it there. That was hard. That required a certain need to create an incentive in the copyright model. So that made sense in that world. But now we've moved into a new world, the information age, the internet age. And I think we have to look at new business models that harness the properties of the internet rather than trying to fight against those properties, meaning like the ease of copying and the ease of distribution. These are the properties of the internet, and we see traditional business models really trying to fight against those, when I think they should turn it around and harness those properties, because that's where the future is headed. So business models perhaps where things feel free but aren't actually free would be an example. Just take, for example, over-the-air television. It feels free because you don't put in a quarter every time you want to watch a TV show, yet all the producers and the actors and such are in fact paid through a different type of business model. So I think if we just kind of can look to the properties that the internet has and try to harness those properties with the business models rather than fighting against them, because it's a losing effort to try to fight against the ease of copying and distribution that the internet offers. Thank you.
Okay. Yeah, I think one of the problems is indeed that our regulation and also the business model are coming from a time where we had clear controlled territories. So, and it was linked to a territory, and then we managed, you know, cross-border issues in a separate way. This is gone with the borderless internet. I will ask Leslie in a minute about, you know, options, you know, how to manage this conflict. But before that, I wanted to ask Jānis Karklinš. the Assistant Director General from UNESCO, because it's much older than WIPO, and you are dealing with these issues, you know, for many, many years. What is the UNESCO's role now in this global debate?
No, actually, UNESCO went out from the debate on copyright protection and passed it on fully to WIPO. But I would like to raise maybe a little bit different aspect. Even here we're thinking in terms of existing systems or existing possibilities. But when we, I think, resolve this issue, we need to think completely out of the box. We need to go back to the beginning of the internet, and which is, in a sense, has created this problem we're facing today. And I'm referring to a perception that everything is free on the internet. And actually, we're very accustomed to pay access to internet, and we are not prepared to pay for the content. And I think that this is something which we need to change, because content is not free. Only cheese in the mousetrap is free. So content is not free, and we need to acknowledge and accept that we need to pay for the content. So how to do it? And this is the way how we need to approach this issue, and think completely out of the box, and think whether this perceived gratuity or free of charge internet is the way how we can really address issues we're talking about.
Thank you. You know, money is still collected mainly on a national level, Leslie. So, but we have this global world. So, how you can get then, you know, if you have to pay for it on Tuvalu, you know, how to get the money to another place.
Could I ask a question?
Jānis, not everything necessarily has to be paid for. Some people are willing to share their information without compensation. So I hope that your assertion is not intended to be universal.
Maybe if I can come in on this one as well, Wolfgang, just for a little bit. There is no free. I mean, you know, I think it's an illusion to believe that there's free versus paid for. When you access free content, you have already paid your broadband subscription. You just got yourself a pretty nice smartphone, et cetera, right? So it's not exactly as easy as that, right? So the revenue might have shifted in the value chain a little bit, but you don't. I mean, it's not like you just pick it up on tree, right? I mean, you pay for other services that get you the access and the hardware, the infrastructure. I think the important thing is how to distribute that, you know, that revenue more properly. I don't know, more properly, or to distribute it properly.
Yes, we know from Milton Friedman there is no free lunch. Somebody has to pay for it, so even if it's free for you. But, you know, let's come to the legal question, and then I will ask also Hong about the, you know, what the situation in China is with the new version of the copyright law. But let's move more from a global then to back to a national perspective. Leslie.
Thank you. Actually, before I get to that, I think having heard the remarks this morning, I'd like us all to take a little bit of a step back and remember that our current notion of what performance is, or what a work is different than it was a few hundred years ago. And in fact, the whole notion of what is a piece of music today is perhaps a little bit different than it was in Beethoven's time, when part of your purpose was to entertain somebody, your patron, for an evening, for instance, and that shaped the nature and length of the type of composition that you might put together and perform. And indeed, the whole funding model around performances at that point was very different from anything that we're used to today, whether you were a bard in a court, or more recently, again, a composer with a patron. So, and as Robin mentioned, the whole notion of what a book is and what it took to publish is very much shaped by the technologies available at the time. So I think we're perhaps, optimistically, we're at an inflection point where we have a different underlying technology. Our notion of what a performance is may change over the coming years, and that might help ease some of the questions of, so how do you get properly compensated for it so that you can be eating something other than the cheese in the mousetrap. So, and with that, I think the we've said a little bit this morning about the underlying internet technology. It's, there are new opportunities here and also some challenges. The underlying internet technology was built to be essentially borderless. The internet works best when it doesn't recognize regional boundaries, which comes to your point, Wolfgang, that the real challenges that are overlaying of recognition of copyright, recognition of performance, and how to pay for it is really much more based on regional boundaries. And I don't think that the right answer going forward is by trying to make the internet regional. Today, as it stands, if you seize a domain in the U.S., a website falls in Germany. And that's an inherent and positive aspect of the internet that we need to preserve. So how indeed can we get to the point where there are perhaps meat space, real-world agreements to recognize globally the rights of artists, irrespective of whether they are within your given regional domain or somewhere else in the world entirely. And that's not an internet technology problem to solve, although hopefully some of the underlying technologies can help support whatever we humans come to agree.
Thank you, Leslie. But before I will ask Hong about the situation in China, I will come back to the issue you have raised about, traditional funding systems in the Middle Ages or whatever, how this was sponsored. I think Felipe Sanchez from Mexico, from law school in Mexico, has an own idea about this. Probably, this is the right moment that you can make bring this to our table here, and then we can also comment about your proposal.
Thank you, Wolfgang. Well, I believe that I completely agree with David in the sense that Creative Commons is not for everyone, just as the traditional copyright system is not for everyone as well. And, we have to find alternative ways to adequately compensate authors and copyright holders, in a sense that we're actually spending a lot of money in enforcing copyright around the world. Maybe we can think of a formula in which this money that is being spent in enforcing copyright may be directly paid to copyright holders instead. And thinking of a way to blanket license digital use of works in the internet, and only in the internet, because I don't want I don't want this idea to get misunderstood. I don't mean liberating content for everyone and for every use. No, I mean only in the digital environment. We should be thinking about a blanket licensing scheme paid by the government, maybe, not through additional taxes, not through additional payments made by the citizens, but instead just thinking about that idea that all the money that's been spent in enforcement may be spent in licensing instead. And that way we can have a more healthy internet system, a more healthy digital environment. The IPA is an arena in which regulation was decided by a few, not so many years ago. And, the internet has brought IP regulation into the sight of everyone. And it has turned out that the IP regulation may not be crafted by a few anymore. The IP regulation system has to adopt a new multi-stakeholder system in which everyone that has an interest, including users, as rare as this can sound for someone, have a saying on how we should shape these new regulations. And maybe one of these exits is through establishing a blanket licensing system worldwide, maybe. I mean, today we're having a session at WIPO about the International Music Registry. Why don't we think about an international blanket licensing model so that copyright holders can get paid, internet service providers can be just in peace with what they're doing, and the users are in peace as well for using contents that are on the internet already.
I would be very interested in to hear David's and Martyn's and also Robin's comments on it. But before we come to this, let me introduce Hong. China was criticized for many, many years not to respect intellectual property rights, and then they had their law and they joined the World Trade Organization. So, and now you have already a new version of it, and probably you could inform us a little bit, how this fits into this global debate.
Many countries are revising their copyright law. In recent years, we're seeing copyright revision happen in Europe, in North America, Latin America, and Asia. Especially those big developing countries, like Brazil and India, they're revising their copyright law. Bills are now available for public consultation. China is joining this group. China is going to revise its copyright law for the third time in its 12 years history. A bill has just been released for public consultation on the 1st of April this year, so 23 days ago. I made a quick research of this bill. I can see two prominent features of this draft. The first one is that there were going to be more exclusive rights, more enforcement, and stronger protection for copyright. The second feature is that there will be less freedom of use of copyright works. This is quite interesting development in China. Actually, this kind of a copyright revision is quite consistent with the China's national intellectual property strategy that's been enacted in 2006. This IP national strategy has a special emphasis to follow the American or Japan model that's been proved in last century. That is, from imitation to creation and to intellectual property protection. At the first stage of imitation, copyright protection may be quite low and relaxed, flexible. But when we move to the second stage of independent creation, the government will upgrade its copyright protection level to stimulate more indigenous intellectual property and copyright. And from this strategy, I have three quick observations. It's not only about China, but other developing countries in the world. The first one, whether the Chinese bill is a wrong estimation of Chinese development stage, whether China has really gone over the stage of imitation, or it's still at the first stage of imitation, and whether it's really come to the second stage of independent creation. The second observation is that, of course, the model of United States, Japan, and maybe South Korea has been proved to be, to some extent, successful in the industry society. But the model has not been tested or examined in the information society, and especially in the internet environment, especially in the network environment. Yesterday, the panel talked about the difference between online world and offline world for law enforcement. Internet has changed the speed, the skill, and the scope of communication. Whether the model has been really effective in offline world, in industry society, will be successful in the information society. That's a big question. It's a big question for those big developing countries. They're choosing their development model. This is more than business. This is more than business model. That's more important. It's important for the whole country. The third one is interesting. I've listened from the colleague on the panel. They talk about alternative models. If there are alternative models, it could be learned and presumed by these big developing economies. I do believe they're going to presume those models. But issue here are whether these models are really available and sustainable. Okay, back to you.
Thank you. That's interesting. It will probably also provoke a number of questions. I will already announce that in a couple of minutes, we'll open the floor for questions from the floor. We have also two facilitators who will facilitate remote participation, and I hope there will be also some questions coming from there. But before that, let me go back to David and to Martyn to comment what.
Okay, I will go first if that's okay.
Okay, David.
So I heard a lot of comments. I will try to deal with them very quickly. One of the arguments made is that the digital distribution is cheaper and easier and faster, and that that maybe we need to change the business model and so on. The fact is, in music, distribution of physical product was never that big a portion of our business, and digital distribution isn't either. Perhaps it's good to talk for 30 seconds about the music industry. We are venture capitalists. We go out and we find talent, we invest in bands, and unfortunately, like Silicon Valley always says, 1 in 10, 1 in 12, the rule of thumb in my industry is 1 in 20. So we go and we sign, give them an advance, and record music, shoot videos, subsidize touring, and then, of course, in some cases, hundreds of thousands or millions of dollars in marketing. And still, only 1 in 20 makes money. 17 out of 20 lose money, and a couple break even. And so to equate the value of music with distribution, it's a red herring. It's really not the case. The development of intellectual property is investing in that development of intellectual property. That is the main cost. So I think that people say, well, it's cheap to distribute on the internet, so you should change your business model. More than 50% of the music sold is digitally distributed in the United States now. And we have every kind of business model. You can download a song while you're riding in a car on your cell phone. If people have ideas for business models that we're not currently doing, please tell me, because we pretty much think that we've satisfied most people. For the price of my coffee this morning, I can buy about 7 songs on iTunes for 1 cup of coffee. Now, we're in Geneva, so I would say in other countries, you only get 3 songs for a cup of coffee. But the main point I want to make is that people want professional content. We know that the consumers on the internet, of the most streamed videos on YouTube of all time, 9 of the top 10 are professionally created music videos. That's what people want. Now, number 6 is Charlie Bit My Finger. It's a viral thing. But the reality is that most of what people want to see is professionally created content. They are not clamoring for amateur content. So we need to invest in the creation of high-quality content. And the only way to do that is make sure that money flows back to the creators. How we do that exactly, I mean, that's what we're here to discuss.
Martyn, professional content, this is what you are doing.
I would love to find out where these record companies are that are investing heavily in artists at the moment, because it's not happening. It's happening at the top 1 or 2% for the people that are on TV all the time and your Beyoncés. For the giant sway, the middle-ranking and lower-ranking professional musicians, there is little or no investment in there. In fact, it makes me quite angry to think about it, how little investment there is. I can give you an example. And this is not I'm not just talking about no-hopers here, or the 17 out of 20. The band Massive Attack, which have sold tens of millions of records internationally, were told by EMI Records that they were not going to be signed, or their option wasn't going to be picked up because it was too expensive. But if they wanted to re-sign with no advance whatsoever, because this is what they were giving all the artists that they were signing up, the basic standard, and this is the same throughout the whole of major record companies now, is unless they are forced into a position where they're in a bidding competition with someone else, they will not give an advance for anything apart from recording costs. This is entirely different to when I was starting out in the 80s, where record companies did exactly what you were saying, and they did invest in the creative future. So I think it's a specious argument, to be honest with you, and I also think that we need to look at how we're going to maintain the quality, I agree with that much, of video production, of record production, but the current model is not doing it with major record companies.
I mean, I have to take, I won't say offense, but I understand your position. The music companies have lost the vast majority of their revenue, and it trickles down all the way to the performer, to the creative artist, and that's the problem. It's not like the profit margins are so high. When a music company like EMI is public, you can look. Their profit margins were 3%, 4%. Apple was 39.5% last quarter. So
can I just intercede? I've got a very short story. We my band Heaven 17 were a very successful act in the 80s. We sold probably 5 million records. We didn't receive a royalty check until 6 years ago from recording, because of the amount that the record company were charging me to produce our own records. It was all going back to my personal account. That's the absolute truth. And I know many, many people who will never recoup in their entire lives. So that model itself didn't work, and I agree that there's a whole bunch of people scrambling to get a much bigger slice of an ever-decreasing pie. We've just got to look at creating a new pie, frankly. That's what we should be talking about today.
I think the profits are partly also dependent, from the time. You had good times. You had good times and bad times. I think for the music industry, the 90s were a golden age. And if you compare figures today with the 90s, then it's lower. If you compare it with the 60s and 70s, it's probably higher. So that means you can have all kinds of statistics which would say something. Or when you say 38% with Apple and 3% for the music industry, it looks certainly low, but it's a complex process, and the user is certainly playing an important role. Is he ready to pay or not? My impression is people are ready to pay for something, but they want to know more, how the money is distributed. They want to have more transparency. Robin, could you comment on this? And probably then Sacha and Hong, and then I would ask Vint to summarize a little bit the first session, because then we go to the coffee break.
Yeah, thanks. I wanted to take issue with the idea that we won't have music, we won't have great art, books, literature, if we don't have this current model of copyright. I think it's worth remembering that copyright is a recent invention, largely created Statute of Anne in 1710. So we had lots and lots and lots of professional musicians and music, Mozart and Beethoven and Shakespeare and all of these great artists managed to create in a world that didn't have today's copyright model. So I think that while I agree we want professional musicians, I don't think that this one recently created model is the only way of achieving that.
Robin, we also didn't have the internet. And if we had, I suspect that if Shakespeare had created a product that was easily distributed on the internet, he would have had to get a day job.
Man.
Okay, now it gets very lively. Leslie, you want to react, and then Leon again. And then Sacha. So I have to bring now a certain order in it. So Leslie, Leon, Sacha.
Thank you. I wanted to make a couple of observations underlying today's discussion, because we are, I think, conflating both production quality of the actual content that is being consumed, which I certainly take David's point that people want good quality production, and their question is how to invest in order to get that. I'm very depressed to learn that all of the money that I spent on buying Heaven 17 music went to the company and not actually to the artists, since I don't think I bought any in the last 6 years. But we also have been talking separately about the question of how do you create not just the production of the works, but the actual inspiration, the people who are inspired to create works, which is a separate thing from the production quality of the ultimate works. I think we need to separate those things. Whose rights are we actually trying to protect in this? And I asked David the other day whether or not the internet, if David is a VC, how is the internet helping you find new prospects? Are your numbers changing in terms of if you only get 3 successes out of 20? And I understood your answer to be no. So I think that what that said to me was that this is still ultimately a popularity contest from your perspective, which is a different thing from a question of quality of composition. And in fact, were Beethoven writing music today or Shakespeare writing plays, I think is more of a question of would they have been popular enough to make it on the internet, which is a fundamentally different question than how do we manage copyright.
That's an interesting perspective, Leon.
Yes. I agree with Robin that copyright is relatively new. And the humankind, is creative by nature. I mean, we've been creative since the beginning. We didn't need copyright laws in order to fuel that creativity. And the other fact that the industry has to accept is that their content is not the only content anymore. So we have this vast amount of creativity being produced every day by users. And to see the traditional channels of distribution as the only channel or the only way to get access or to consume contents, I believe it's a mistake. One of the things that the industry has to open its eyes and take into account is that they're not the only players anymore. This pie has become smaller, yes, and they have to find new ways to survive, just as everyone else in this world has to look for new ways to survive. And we would gladly help them if they didn't criminalize users. I mean, everyone here is happy to help the industry survive. We have no problem with them making money out of their content. Yes, but we don't want our rights to be taken away.
We know the internet is a layered system. Probably we went up in this field also, with a layered system that we have, for different categories, different systems. Sacha and then Rolf-Dieter, and then I would go back to Vint.
Just a point, picking up on Leon's point, I mean, strictly speaking, as an economist, right, copyright is there to incentivize creativity, right? I mean, we often forget that, but that is the basic premise of it. Now, one question which keeps me up at night, and I'll ask that to Martyn, actually, given that we have an artist here today, is how do these new business models do that job, incentivize creativity, and are these new digital content models that are emerging sustainable from that point of view? We have quite a clear idea on what the new business models look like, right? Pay per track, you don't buy an album anymore, just this one song. All-you-can-eat subscription plans, Deezers, Hulu, et cetera, So these are all you-can-eat kind of, or advertisement-based business models, right? The connection between the actual full album, the artist, and the user actually might be, bigger than ever. And I wonder, just strictly speaking as an economist, how would the artist fare in this new digital ecosystem? Worse or better?
Wolf-Dieter.
Well, maybe I'm a bit the naive scientist here. What are we talking about? We are talking about creativity and getting reimbursed for the creativity. Okay, you can be creative without asking for being reimbursed once you can afford it by yourself. That's one thing. And then things would be free, and the user has to judge the quality or the content, the quality of the content you are delivering. The second thing is, you want to be creative, but you need the money for it because you need to survive. Again, the user will judge what you are doing on the, maybe not necessarily on the quality of the content. I mean, I'm not so sure if the user is able to judge on the quality of the content all the time. But why not taking a simple model, and those who can afford it by themselves, they put things on the web for free. Those who need to get their living from it, they need to be reimbursed. For example, each time you open their web page or each time you start the song or whatever we are talking about, and they get paid through that, through the clicks, the number of clicks or whatever, because you cannot charge, you cannot increase, for example, for the service of the internet, because then you punish the people who are just looking for general things and not for songs or whatsoever. But why not trying to distinguish between those who explicitly put it on the web for free and those who explicitly put it on the web, you have to pay when you open that? Isn't that a model?
Vint's notes get longer and longer, and probably now you have the next 5 minutes to react to all these various interventions, broad range of issues.
Well, the easy summary, of course, is there's a lot of different opinions here, and there's no consensus, and that's my summary. First of all, I think that we should be very thoughtful about the fact that we're talking about a more complex ecosystem than we had before we had the net. There are different ways now of distributing things, it's easier and so on. a lot of the business model discussions tend to start from a premise that there's only a certain way to do something. And my sense of this discussion is an interest in discovering alternate ways of achieving some of these objectives. I don't think that we should go away from this big tent notion that lots of different models should be permitted. So if someone creates something and says, I wish to be compensated for it, they should be able to make that assertion and have mechanisms available to try to make that happen. An awful lot of the money that's generated in creative works comes about in part by controlling access, whether that is a performance which you control by either letting people in the door or not. And this is a non-reusable kind of access because the performance happens, it's ephemeral. If you weren't there, you don't get the benefit for it. You generate revenue by paying to get in. There are ways of creating performances that are reusable, and that's what recordings are about. And you can look back over history and see a variety of different ways in which these reusable instances happen. It used to be printed sheet music, used to be a very common way of generating revenue, and I don't know how much is generated from that anymore. Then recording mechanisms came along. So what I'm struggling with here is to say that this group shows evidence of an interest in looking more broadly at different kinds of models and also accepting the idea that at the far end of the spectrum, at some point, the purpose behind copyright was supposed to be finite, and that at some point it isn't controlled anymore. It becomes part of the public domain. Now, I know that's true in the print works. Am I also correct that this is true in the other works? That being the case, we haven't talked very much about the seed corn of creativity, and public domain material is that seed corn. I don't know how many movies I've seen that have plots that are derived from materials that have become public domain. Let's not forget that that's the other part of this equation. So clearly, no complete resolution at all. Big opportunities to explore alternative ways of either producing revenue or sharing content, and ways of feeding the creative process.
Thank you, Win. May I ask the remote moderators whether there are some questions meanwhile from the remote participants?
Hello. Yes, we have some comments and some questions from remote participants. We have a comment that today at the same time we are here, a few blocks away from here, the World Intellectual Property Organization is having the event called International Music Registry Roundtable on the Information Interests of Music Users in Geneva. So it's like a... And there's two questions from Ellison from California. He says, how to compete with free? And also, why not giving away the content and get revenue from other things like merchandise, tickets, etc.? And also we have a comment from Eric from Mexico. He says the industry is developing systems to protect copyrights, sometimes even forgetting the author side. And the internet community, say users, are developing systems to make more easy distribute the information, content, and also to create content. How can we advance in creating bridge between those parallel processes? It is possible to create a hybrid system and a model that have the best of both worlds. And final question from California also. What model is going to be easier to the end user than something like BitTorrent?
Okay, thank you. Somebody wants to reply to one of the questions? David, I think you certainly will react to it. And Hong? Yeah?
Okay, these are very difficult questions, but I think about whether the legal professionals can make some contribution to this very interesting discussion. We've been talking about business model. It's very clear there's no one-size-fits-all solution. This public levy system, there's a global registration system to facilitate licensing or open licensing system, all very open-minded. But let's think about the law per se. The copyright law is an exclusive protection, but they're not absolute. There's a couple of restrictions on the scope of protections itself. There's a fair use model in the United States, and there's a fair dealing model in UK, and limitation and exceptions in European continents. And so if these limitations and exceptions are really effective, we can see there are actually plenty of wiggle rooms for user to use the copyright works. And another thing I guess is very important that should be raised as public domain. The father of Berne Convention, Victor Hugo, he emphasized the importance of international copyright protection, but at the same time, the copyright protection should expire at a certain time. It shouldn't go for good. It's against public interest. So we should look at the inherent limit of copyright per se, and rather than make it an extreme protection.
Yeah. Okay, meanwhile, there are a number of questions here in the room. David wanted to react.
Yeah,
and Jānis Karklinš has to leave a little bit earlier. Probably he also can just make a short comment to the questions, and then I start to ask people from the floor, and we should prepare for coffee in around 10 minutes.
Okay. I want to touch on this one issue. It comes up quite often, and that is the length of copyright. So there's a lot of people who are pushing back, 50 years after the death of the artist, or 70 years, when territories differ. The reality is that on the internet, your copyright protection lasts about 11 minutes. I use that number because in the television industry, 11 minutes after the end of a television show, the whole show with the commercials edited out appears on P2P and link sites and lockers. 11 minutes. So I think that we should be happy to revisit things like the length of copyright. That's a completely separate issue. But right now, creators don't have any protection in many cases.
Okay.
There's one thing that we haven't mentioned, which I think is quite interesting if we're looking towards the future, which is in the very near future, I think none of us will actually own stuff. I mean, we're going to be paying for the right to stream everything. I mean, it's already happened with Spotify. My teenage children, listen to Spotify or YouTube all the time. They don't care about my iTunes collection. They don't care about their own iTunes collection. And so we've got to also look at how that mechanism is compensating artists. And at the moment, it really isn't. I mean, Spotify is an appalling example of how not to do it. I mean, it's great from a consumer point of view because it's free, essentially. But from an artist perspective, it's infinitesimally small amounts of money get back per streaming event. If we're moving to a world where we are not going to own books, we're not going to own everything's going to be streamed, Netflix, etc., etc. There's going to be less and less revenue getting back to the actual creators, and this is a major problem.
Martyn, can I just comment quickly? I saw one estimate that said that a song would have to be streamed 400 times on one of these services to equate the same amount of revenue for all of the creators. So they were comparing a 99-cent iTunes sale to the stream 400 times to get the same revenue. It's a broken model, unfortunately.
Yeah, I agree with that. But I also think that the iTunes model is a problem as well, because that's based on the original kind of subdivision of royalties, which is based on a flawed model.
But I would much rather be fighting about how to divide up the money.
I think it was said in the beginning that we have still too little facts. So that means a lot of our plans for the future are estimates, a little bit speculation, because we do not yet really fully understand the economics of this new world, how it works, how much small money is needed, to get the big money, and how big money is needed to stimulate the creativity. So when we move now to the Q&A session, then I would ask people to introduce themselves and to direct the question to one of the panelists, and to be rather brief with the question, so that means no long statements. I think Bertrand was one of the first, and so we have now to find a certain order. 1, 2, 3. Nick, the first 3, 4. So we do this 4, and then we go for the coffee break. Bertrand?
Thank you. My name is Bertrand Lachapelle. I'm with the International Diplomatic Academy, and I would like to recognize that the content industry has a major problem of having a whole range of geographically defined agreements that have been negotiated for the last 80 or 90 years. It is a problem. We understand this problem. However, what I sense is incredibly lacking in most of the discussions, not only here today, is the desire of everybody to have a societal vision about what we want to accomplish. When I hear people saying there's no such thing as a free lunch, imagine when we were thinking about building libraries on a public interest objective of education. Imagine having the power of pushing a button and creating as many libraries as you want, free of access. What would be the policy decision? What should be the policy decision? Of course, it is not to duplicate anything that is being written so that everything is available for free for everyone. But it cannot be either to say, oh, we will keep just exactly the number of libraries that we have because we can do much more. But no, we shouldn't, because we're going to lose money somewhere. Where is the societal vision? Where is the desire to define where the cursor should be put? The change is qualitative because of the technical evolution. Where is this debate taking place? And with all due respect to Jānis, that I love very much, when I listen UNESCO saying the question of protection of copyright is the responsibility of WIPO, isn't it a little bit like saying, oh, privacy protection agency saying, oh, no, privacy protection is the responsibility of law enforcement?
That's a great question. Jānis, do you want to react?
I think the reasons for passing the task to WIPO was much more prosaic. And you know that in UN system, member states are asking to avoid duplication. So, and this was the only reason why that part of copyright debate, which was launched at UNESCO, I think some 20 years ago, about 5 years ago, was passed to WIPO, where expertise is and knowledge is. But coming to your comment, I think that there is, again, a misperception, maybe what I was trying to say. It is not about whether public libraries are free or not. They are not free. They are paid by public money. They are paid by money what government collects from taxes, from citizens, and spends in public interest. Ultimately, everything costs something, including any content. So, and that's why I was saying that we need to maybe rethink who should pay for it and how the creators must be remunerated if they wish so. I fully agree with Vint that there might be people who would like to share their creations free of charge. And I know, at least to my knowledge, George Michael is the one of the world famous singers who is not charging for his new tunes, which he puts on the internet. So, but there are not so many. We need to think about everybody, and that is in the public interest to create these systems. We're in the new paradigm, which is developing very fast, and our imagination certainly lags behind the fast development. It takes time. It is painful. We need to rethink many things which we are very used to. And that is the thing which I wanted to I wanted to stress. And maybe final point. Of course, entertainment industry is extremely important for any human. That's part of our life. But I must say that the copyright issues or the ways how artists are remunerated for their creativity is not the only issue which we need to talk about. There is a book industry, there is a scientific industry where all the same problems we're facing, we need to rethink basically everything.
Okay, thank you. I have a proposal because there are so many hands now here in the room and it's difficult to get an order in it. So we interrupt 5-7 minutes now for just a coffee and some drinks. I have here a list. And if you want to ask a question, put your name on the list, then we can have a certain order and then you are registered because, this is a problem also, with patent and trademarks and copyrights. We have to have a registration system. And so there are too many hands now here in the room. So please come to the podium, put your name on, and then, first come, first served. Okay, 5-7 minutes, not too much.
Can we produce this many cups of coffee in 5 to 7 minutes? Yeah.
When you say 5, then you know it's 10:15. When you say 10:15, it's 25.
Half an hour.
Ultimately, it is.
Okay, thank you so far. It's different opinions. No chance to have a consensus, but. Okay, thank you very much for coming back. I hope we will have another exciting 1 hour. We have 14 questions now here on the list, so I will ask every person, to be very brief with the question, and also the panelists, to speak directly to the point. But we had still 2 open questions. So Sacha wanted to react to Bertrand's questions on WIPO. And I think Leslie also wanted to make a special intervention, and Mr. Heuer also to the public library. So we start with these 3 statements, and then I ask Riyad Basia, Arun Kumar, and Slim Amamon. Probably I mispronounced some of the names. I hope we will find it. So, Sacha.
Thanks. Yeah, Bertrand, just as to react, on the digital library front and the WIPO front, on the digital library front, I can tell you, and Google will tell you as well, creating digital libraries is really expensive, right? So it's not like just to flip on a switch, etc. So there needs to, even from a public policy perspective, and governments are thinking about this, right? It does take a lot of investment, right? So it's a costly undertaking. There's no free lunch on that one either. On WIPO, I just have to correct that a little bit. WIPO is not really so concerned with enforcement these days, right? I mean, when you look at WIPO's activities currently, there's a lot of pretty creative, thinking on how to make works accessible, et cetera, When I can think of the 3 most important points that we have to face on the copyright front, and I'm sure Francis Gehry will address these this afternoon, one is the management of copyrights, to facilitate that. And the meeting today that was mentioned is just about that, creating an international music registry that would facilitate the licensing. The second point is the role of intermediaries, also being discussed at WIPO. Third and final point is what is really difficult these days is that the user does not know what his or her rights are, right? I mean, and as you correctly said, Bertrand, it varies immensely from jurisdiction to jurisdiction. One day, I mean, as an economist again, a few years ago, I went to lawyers and I said, can you tell me what the rights of users are in Germany, France, et cetera, And lawyers told me, no, sorry, it varies from court interpretation to court interpretation. It also changes, and, I was a bit baffled. So we need to clarify user rights, in particular also with exceptions and limitations. And that's, again, another issue that WIPO is working on, a treaty for the blind, the libraries and education, etc. Now, it's not an easy discussion to have, especially with 185 member countries, all the stakeholders, etc., that are at the table. But it's ongoing, so it's not only about enforcement.
Okay, and Rolf-Dieter also wanted to say something to the library.
Yeah, I think just want to correct that at least in research, we have a sort of vision concerning digital library. Research is to some extent a bit easier because you get the support from through public money. And I think it's important to see that you need open access and open dissemination of information in research, not only for the developed country, but for all countries. This is very important, and that's also the CERN philosophy of open access, open dissemination, and this is why we have a program, partly together with UNESCO, of digital library. That means make the scientific results available to all the countries, but make also the scientific results in these countries available to everybody else, because this is otherwise missing. So it's a two-way road, but you need, of course, the support from the respective governments in the different countries. You can only do it where you have this support. And we are doing it in several countries in Africa, and I hope that we go further and further, but it needs the support from these governments.
So there is light at the end of the tunnel, and probably more light will come with technology. Leslie, why to discuss only business models? Technology probably will offer a lot of answers.
Yes, thank you for that. And indeed, I wanted to follow up both of Sacha and Rolf-Dieter's comments and bring back a little bit of a flavor of technology, because I think one of the things that we need to keep in mind is, irrespective of how rights are assigned or expected around particular pieces of content, that something being available for free shouldn't mean enablement of theft. What we really should be focused on is how can we have an internet that both recognizes technologically and otherwise rights, so that rights are properly managed. If we can get there, and this does require, I believe, some additional support through technology, as I said before, then we can enable new perspectives on what to do with content and how to trade it, whether you should charge a lot or charge a little. But it's pretty difficult to get there if you don't have a system that allows the proper management of rights. And this comes back to one of the remote points made earlier about how do you compete with free. I think that it's not a question of price, it's a question of respecting the originator's requirements, and that includes not having really silly situations where teenage girls are being arrested for or having their content taken down because they were singing some popular artist's songs and they put a home video up on YouTube, which is sort of content protection taken to an extreme. So what do we fundamentally mean by rights? How do we have a right structure that actually matches the global nature of our interactions these days? And how can we sort of drill down into the technology to support and respect the right structure that we have, so that we can support new models of micropayments for individual performances and so on and so forth.
So when Leslie mentioned the teenage girl, then Robin got very nervous. So Robin, you.
Thanks. No, I just wanted to pick up this point about technology and how technology is impacting copyright and music and other kinds of arts. It's not the case that the internet and technology is only hurting artists or only stealing copyrighted works. It's also the case that technology is being used by the entertainment industry to circumvent the user's legitimate rights under the copyright bargain. I mean, these works are supposed to fall into the public domain at some point. That's the deal. That's the copyright bargain that is struck between the state and the creator, that you get these limited rights for a limited period of time, and then it goes back and belongs to everyone. Well, technology can basically make a file disappear at some point. So it doesn't go into the public domain. So being able to prevent people from format shifting is another thing that in a way that technology is being used against user rights, preventing fair use, things like that. These are things that consumers have a legitimate right to under the copyright bargain, but they're being prevented from actually exercising because of technological restrictions. So I just want people to understand that it's not only the case that technology is hurting the entertainment industry. technology is also being used by the entertainment industry to take away users' rights under the copyright bargain.
I think this could trigger another big debate that the industry circumvents user rights. But before we come to this, and I think some people on the podium are prepared to reply to this, I want to ask Riyad, Arun, and Slim to ask a question. Riyad, can
Thank
you introduce
you. I'm here.
yourself and ask the question? Okay.
You can go? Yeah. Thank you. My name is Riyad Bazia. I'm intellectual property consultant based in Geneva, former NGOs coordination office in the UN. Let me start by, I want to tell you that on Thursday, the day after tomorrow, it's the International Day for Intellectual Properties, April 26th. When we talk on IP, we think on copyright and industrial protection. It means Paris Treaty and Berne Treaty since 1885, something like that. And this is copyright and industrial protection. Until the middle 1967 resolution of the United Nations established WIPO 1967, and the building is still running since 1977. WIPO, it was the unique international organization specialized in IP. But UNESCO, specialty is science and education and also culture, which means also new technologies. When we talk on technologies, and after technologies, we got new technologies. But before new technologies, sorry, high tech, it means high resolutions, high fidelity. New technologies, this new generation of technologies, the application on information, we got infotech, the application on medicine. And it is useful, patented, because it's for the interest of everybody. And we got medtech. Finally, we use manipulation and on biology, but it is not necessarily useful for everybody. But I don't want to be larger. I want to say that WIPO management of copyright, management of the interest of the artist, it's not WIPO business, it's a business of organizations, many organizations, but there is opportunities if there is any challenge or problems, which could be by licensing. And nowadays also mediations, it's an important tool, especially if we have any problems in domain name. But I want to conclude that globalization, you are living globalization, but standardization, it's very useful, and harmonization, because e-commerce, it could be, we can challenge it by anything. And the continent of IP, yes, I'm finishing. The continent of IP nowadays, it's another aspect of digital divide. And yes, let me, by one word, say that the creation, there is difference, and discovery. Because CERN was created before thinking of on entity economical in Europe, and it is not necessarily European organizations. But there is creation, there is discovery. Maybe in the future we can think to patent CERN, and I stop here.
Okay, statements should be brief and clear to the point, so we could have an open debate, not only questions. So that means whenever you want to make a statement, so certainly you are allowed to make a statement. But, you know, I have now 14 people on the list, so I put it into baskets of 3. So before we come back to the panel, we would have Arun and Slim. Arun.
Hello, everyone. My name is Arun. I'm a techno freak and a culture addict. That's what I do. And in my opinion, in layman terms, because I don't really represent an organization, creating and producing content creates wealth. I think that's sort of the world that we're getting to. And replication does not. And the last few decades are only proving us that fact over and over again in many ways. And I think the internet is doing it in a speed and a scale that we cannot imagine. And if one wants to create wealth all over again, he needs to create something else. And I think that's my understanding. I think if Shakespeare had word to write in English today, I don't think he would need a day job, because he would still have the Queen's eyeballs on his creations because of the internet. And now that I've shared my thoughts with all of you, I don't know whom to sue for having shared this with the rest of the world on the internet. Should it be the person who put this mic here, or should it be CERN, or should it be the person who's got a recording implement, or should it be somebody else, or everybody else around here? Who's going to leave the checks at the reception? Thank you.
Okay, thank you. By the way, a lot of people argue what fair use was in the past should be fair share in the future, but the question is, what is fairness? So that is also a very interesting detail, to clarify how we understand fairness on both sides in the 21st century. But now let's go to Slim, and then I, give space for the people on the podium again.
Okay, it's me. I'm Slim from Tunisia. I want to begin by addressing Mr. Hughes, who said information and knowledge are different. Information and knowledge are the same, and if you think they are different, that says a lot about the industry you are representing. So the problem here is that we have to acknowledge, everybody, that we can't share knowledge, ideas, information without copying them. I repeat, we can't share without copying. If I listen to a song, can I sing it again? Can I sing it to my friends? Can I sing it on stage? Can I put a video of me singing it on YouTube? This is the root problem. We're talking about ethics. My right to share is more important than your right to gain money.
Clearly, you're not a content creator.
I'm a content creator. In fact, I'm a content creator. But you see, your industry you are representing are putting people in jail for having harmed nobody. Nobody is harmed by copying, but people from Pirate Bay got sentenced to 4 months in jail for harming nobody. This is an ethical problem. How do you dare putting people in jail?
To think that nobody is harmed when you take away somebody's livelihood is extremely naive. I'm sorry.
It's not naive. You are putting people in jail because you're miscalculating your revenues. You're saying I'm losing money, but in fact, you're not losing money. You're just miscalculating your revenues. This is not fair, the least I can say. So I maybe ask Mr. Sanchez if he has an idea, because he's a professor, on the ethical problem of sharing, which is, I think, the root problem we have here. It's not a problem of, it's not a technological problem of the problem of the evolution of the internet or whatever. And by the way, to Mr. Hughes, I have a model for you which is acceptable for me and for us. And the model is, I'm going to pay for the next song of the artist, okay? Because I never, if you create something I never ask it for, why should I pay for it? If you create something and you give it to me because you don't have any other choice than give it to me because ideas are shared by copying, why should I pay for it? If I'm asking for something, if I'm asking you to write me a song for my advertisement, I will be paid for it. Okay, thank you.
Okay, thank you very much, Leon. David, I think you have to reply immediately. Leon first, and probably somebody else. Hong, do you want to say something? Oh, well, and Vint also, and then we go to the next basket.
Thank you very much. Well, yeah, we have an ethics problem in the net, absolutely. The thing about downloading music for free, it's not if it's permitted or if it is illegal, because from country to country this may vary. I mean, in Mexico, to download music is permitted by law. We have a private copyright that we can exercise. I believe this is not the same in the US. In the US, downloading music should be illegal as far as I'm concerned. Maybe there's a fair use thing in it. But the thing about downloading music for free is, I believe that if you like something, you should pay for it. And we have the example of how many, I don't know how to say this in English, but in Spanish is, ¿cuántos granos de arena hacen un monte? Oh? How many sand
grains of sand?
Yes. How many grains of sand make a mountain? I mean, if one downloads a song for free, maybe it isn't harmful for anybody. But if millions of users download the same song for free, well, then maybe we're talking about an ethical problem that you just correctly signaled. We have to ask ourselves, is the content we are downloading worth paying for it? And if we're willing to download it, would we be willing to pay for it? I mean, in the end, there's nothing for free.
Just a small remark. I think the problem is there. The ethical problem is there. Specifically in ideas, I think the value should be put on people, not in goods. Or you're saying that content is a good. If we put the value in people, like I said, I'm going to pay the artist for his next song, okay? We solve the problem. This is an easy solution. Why you just don't adopt it?
I don't. I mean, Sacha may agree. I don't know if it's really worth engaging. But we can go back to Article 27, Universal Declaration of Human Rights. I mean, this is pretty universally accepted thing that says
this is not true.
People have a moral and material interest if they create anything to have some protection and remuneration.
I'm sorry, this is not true, and this cannot be said. The 27th article of the Universal Declaration of Human Rights doesn't protect copyright, it protects authors. And we are seeing now a shift that tends to qualify copyright as a human right. And you now are getting declarations signed by governments that fundamentally list in that order the need to protect copyright, comma, freedom of expression, comma, privacy. This is not the right order.
May I add something just to finish the...
Sorry, I have to add something here. Copyright and right connects, but nowadays protecting authors, yes, but without going to human rights. It's a kind of licensing. Copyright and right for connection.
So
comes to human rights that are very individual rights. We should not forget it. The right to freedom of expression is a very individual right, and also other rights in the Universal Declaration are individual rights. We have institutional rights which are different, and the First Amendment in the US combines free speech as an individual right, free press is an institutional right. So we have to have certain clarity if it comes to the legal nature of certain rights. But Leon, and then I want to go back to Vint, because Vint is waiting already for.
Thank you. So to complete my answer to your ethical question, I believe that to add to what Bertrand has said, as we should revise our ethics on downloading for free, the industry should revise their ethics for pushing laws that threaten our fundamental rights. I mean, we have to find a balance in which we can find a law that respects copyright owners' rights, authors' rights, which are the most important, I believe, as just Bertrand said, and our right to privacy, our right to freedom of expression, our right to access to information, and our right to due process. If we can find that solution, then we'll have a winner initiative.
So, Vint, is there a chance for a win-win situation?
Well, first of all, the idea of paying for the author's next or the next song or next work. John Perry Barlow, I think, also expresses this. He's happy to give away whatever he does as long as he gets paid for the next thing. There's subscription, by the way, is a kind of philosophy like this, where I don't know what it is, but I think it's so good that I'm willing to pay ahead of time by subscribing in the hope that, that I will get something I enjoy. I just wanted to make an observation about the difference between the various kinds of information. I'm going to use that word generally to speak also to musical works, and let me just use the word information, and say how distinct these various things can be. When you look at what happened when the World Wide Web was created, one of the features of the browsers was to expose the source code of the web page that you downloaded. The thing that allowed is for people to learn how to make web pages. So there was copying going on, there was learning going on, it was a very organic thing. I'm not trying to equate this with a work which is produced with the intent of remuneration. I'm only trying to say we should distinguish among these different kinds of categories because they are not uniform. Finally, I think, along with Bertrand's observation, surely we would like it to be the case that if you create something, you should have the right to decide what should be done with it and whether you should be compensated. This raises an interesting question. If you want to be compensated and you put it in a medium where it's impossible to maintain and manage that compensation, then you've made a mistake. So either we arrange for the medium to cooperate with your intent, or you should think twice about where and how you choose to share that creation.
Your fault. So Bob Hinton, Paul Brooks, and Evelyn Lewis. Bob.
Thank you. Yeah, I'm Bob Hinton. I do a lot of stuff on the internet, but I'm speaking as largely a consumer of media, music, and so forth. So first of all, I agree that people do want professional content and are willing to pay for it. I pay for it. I use it. I respect the artist. But I think the system has really gotten out of balance. We've seen the life of copyrights have been extended largely to infinite, as opposed to what was originally intended of a fixed period of time. We've seen the elimination of fair use. Making it hard or illegal to make copies of material that I purchase. I can't transfer the ownership of digital media like I can do with physical media. If I buy a book, I can give it to someone. If I pay for content and buy a movie, I can't give it to anyone. I can't or even digital book. I can't transfer the ownership like I can do physical media. We have location-based restrictions. I can't, if I have a Netflix subscription, I can't download music when I'm in Geneva, only in the US. This is all, the balance for what consumers are getting has been radically shifted from what it is, and it's not very surprising that lots of people feel that they're forced to download things illegally because they have no other choice. They've made the industry, and I think this is not the artist, I think this is the copyright industry, which is maybe represented at the table, have changed the rules so much in their favor that they're almost forcing people to break the rules. And it's also, so I think that if we had a better balance here and it was easy to use digital media, I think there would be a lot less piracy of media. I think a lot of this is self-created, and the estimates for what the actual losses are, I think, are greatly exaggerated. I also sort of noticed that the penalties for doing this seem to be going up and up. It seems like if we go to the current trend, copyright infringement will be a death penalty crime. You'll be executed because you downloaded a song. I mean, this is just crazy. So we need to find a better balance here than we have now. And we can't just make it more and more restrictive. Thank you.
Well, I can only speak for the music industry, but the first point you made, which was you felt restricted on your use. Well, it's 4 or 5 years now since the music industry has pretty much universally dropped DRM. And then I can't speak to other media forms, but our music is universally sold without any kind of technical limitations to what you can do with it. But then your second point is, okay, so I want a book without DRM, but I also want to be able to sell it to somebody else. Well, from a business owner's point of view, the only way for you to give it away or sell it or transfer it would probably be to have it passed to them.
No, so I didn't say there shouldn't be DRM. I said there should be a better balance of the rights for DRM. I should have some rights too. I should be able to sell that to someone else or give it to someone else.
But what I'm saying is the reality is the reason that you can't, in the case of music, where there's no practical model right now, is because there's no way to ensure that you gave up your ownership when you transferred to somebody else.
I think there easily could be. That's not a hard problem, but someone has to want to do it, and I don't think the industry wants to do it.
This brings us back to the fairness issue, but now I have Paul and Evelyn. So, and then we come back to the panel.
Thank you. Paul Brooks from the Internet Society of Australia, and I have 2 points which may not need a response from the panel. 2 observations. Earlier, one of the panellists suggested that we don't really understand the economics of the new business model. I'm not convinced we really understand the economics of the old business model, or even if the old model would be considered optimal if it was one of a choice of a tick box of 3 or 4. My second point is that I'm very glad in this entire debate on digital content and copyright that nobody has suggested that ISPs or the transmission path have a role to play in the rights enforcement has been played out in the Australian courts over the last couple of years. Thank you.
Yeah, somebody is proposing that the intermediaries, the ISPs, should play a role. Hopefully not. Here, so that Evelyn.
Hello, I'm Evelyn Lewis, ISOC chapter Sierra Leone. I have a few questions. Well, I'll just kind of limit it. Is the question right now about the model to monetize, or is it about the right of the ownership? Can you separate those 2 questions, or do they have to be addressed in a combined fashion? And where can one go to find information about business models to try about monetizing, whether it's on a free distribution concept or other kind of concept? The reason being that in Sierra Leone, immediately after the war ended, one of the industries that took up quickly was local artists returning back, creating lots and lots of content, and you go to stadium shows with 50,000 people and things like that, and being able to sell their CDs. And then piracy took over, basically killed the industry, whereby you go to the producers now, you write your song, they say, no, we're not interested, we're not going to be profitable because it's going to be pirated. So we have this problem whereby it also brings a potential civil chaos, whereby at times the artists tend to chase people on the street with whether it's whatever ammunition they have on them to say, stop pirating our music. So I was trying to see where's the equilibrium here to try to see how to find a way for them to earn something off of theirs. So I'd like some answer to that, please.
Sacha Hong, do you want to reply to this?
Just on the ISOC from Australia, and I fully agree, right? I mean, in principle, looking at it from an economic perspective, you would like to benchmark a new model against something that exists and that you have. But the data on both sides is equally hard to get at, right? I mean, how was money distributed previously? I told you it was a CIA agent job to actually identify that. I am a bit worried, though, that it's getting worse, right? And I made this point already with the subscription models. And in principle, we should have the technology today to replace less efficient other forms of remuneration that existed in the past with improved ones, right? I mean, you should, even with streaming models, I'm getting back to Martyn's point, you should be able to track, right, who's streaming what. You should, or Google should be able to see who's watching music video X, which is paid for by an advertisement Y, and there might be potential for a more direct, more fair remuneration that all of us in the room would probably agree to. I feel it's not going in that direction at this point. One of the reasons is, unfortunately, also that this whole DRM discussion went wild, right, a few years ago, and everybody got in their minds that DRM is the most evil thing in the world. Some sort of information management and rights management through DRM would exactly be needed to facilitate that, just redistribution. So let's give this information management and new online licensing DRM maybe a second chance to get at what at this just remuneration.
Okay.
Okay, I want to go to the point of users' rights. I guess it's very insightful things for us to think about. We've been thinking about intellectual property protection as a positive and starting point. But let's think about, we used to define users' right in the copyright law reversely. What is accepted from the user's exclusivity, that is users' rights. If we define the user's right positively, set a positive agenda, then it is possible to protect this kind of rights reasonably. Let me use two examples. One example is the DRM. Many people read that, and I don't against DRM generally, but DRM adoption could be a serious infringement to the user's rights. What I mean is protected and the copyright law for the users to use certain work freely. For example, under the Berne Convention, you can make quotation or citation of a work without permission of the copyright owner. But the DRM has been imposed. I cannot make such a quotation and make the work available through this kind of use. This is a kind of restriction to my freedom that's already available under the law. Whether my user's right could be implemented and ask the DRM to be removed, that's one interesting thing. Another thing is private use. I'm very impressed by your comments about this issue. For the private use, we need to separate two scenarios. One is that you use the work for your private purpose and keep it to yourself, keep it in private sphere. And I copy the work, translate the work, adapt the work, remix work, but keep it to myself in my home. In that case, I don't believe copyright owners should interfere you at all. And if they do, there's infringement to your privacy right, that's your human rights. What is being interfered is a kind of public communication after your private use. You remix the work and post it on Facebook and available to hundreds of friends to view that. That is the issue of copyright. For that issue, I guess there's a Liam's proposal, like a public levy to compensate the source of your remix products. But for this part, I don't really have the solution.
Thank you. Leslie.
Thanks. I wanted to come back to the question of new models and what might they be. I think one of the things that's been tremendously powerful about the internet is that by putting a bunch of building blocks together and letting everybody on the face of the planet build out new systems, we haven't been limited by any one person or organization or system's creativity or limit of imagination, which is a long-winded way of saying I have no idea. But I think that it's important indeed to come back to building blocks, which is why I was saying a few moments ago, if we can look at technology in terms of supporting creators' expressed desired rights in their intellectual property. I'll take us to a slightly different space. Any number of creative pastimes, hobbies, are finding different ways of creating user groups on the internet and facilitating the sharing of, for instance, patterns in knitting, which happens to be my own soft spot, yes, passion. And I mean, a knitting pattern is essentially a creative work. It articulates a set of instructions for creating something that somebody thought up and published. It's not a lot different from computer programs, so on and so forth. How can we share those kinds of patterns in ways that actually support the original creator of those patterns in it? And I'm singling out creative works and crafts because these are areas where we haven't traditionally seen really large industries and lots of money. But it is an area that certainly should be covered by whatever is appropriate in copyright going forward in the internet. I've also seen in the context of those artists trying to make this work that they over-constrain themselves. If they say, to Slim's point, if they get too concerned about whether or not you can use my work, or you can use my work to knit something that you're going to sell, and create far too restrictive a space around themselves, they undercut themselves, and they can't win the popularity contest that David has outlined is the actual success in the music industry. They can't get visibility enough to actually support themselves going forward. That's not a dollar amount question. That's a question of if they have to restrict access to their material by not putting them in an environment where it might be copied, they can't become visible. So it's a much more complex system. Let's get back to the primitives of how do we articulate what rights we want to have on our material and use that as the basis for generating new novel ways of sharing.
Okay, time is now running out, and we have on the list Reinder Roestema from the Netherlands, who requests 2 minutes and 10 seconds with a quote from Nelly Cruz. You have just 1 minute and 10 seconds. Then we have Werner Staub and Nick Ashton.
I think I will succeed in 1 minute. This quote from Nelly Cruz, that's in Europe, the digital, here on the second row, the commissioner responsible for the digital agenda. My student found a speech from her on 19th November 2011, which I think contains a very good phrase. But let's ask ourselves, is the current copyright system the right and only tool to achieve our objectives? Not really, I'm afraid. Meanwhile, citizens increasingly hear the word copyright and hate what is behind it. Sadly, many see the current system as a tool to punish and withhold, not a tool to recognize and reward. So, in that sense, my question is directed to Vint Cerf. We should have something to facilitate the appreciation, and on the level of the internet culture, we have this already. Think of things like link, subscribe. We do this. We do not have an ethics problem on the net, I would like to stress. And we should not pay for all consumption generally. Because what you want to do is you want to discover, scout, and taste yourself before you want to compensate and show your appreciation. It's often professional content, often said, but not always, not necessarily. Sometimes I'd like to appreciate amateur or activist content for whatever reason. Let it to me, leave it up to me to decide if I pay for something. Respect the autonomy of the consumer rather than to criminalize the end user. So, my question, we do not currently have a frictionless system that works worldwide independent of all kinds of Apple or Facebook or whatever platform. And we should build something into the lower levels of the internet protocols. And how to do such a thing. And I'm quite sure that Vint Cerf has at least considered this at some point or came across this issue.
So, any recommendations for the member states of the European Union?
Well, actually, first of all, Leslie and I think, may agree that building it into the lower levels of the internet protocol may be the wrong place. So let me not speak to implementation for a moment and simply say, if you have a medium like the internet, and you want it to have certain desirable features and characteristics, you can choose where to put those to be most effective, and in fact, what we're talking about actually belongs higher up than lower down, in my view. But what's important here is to talk about what those desirable features are. This is what Leslie was getting at in her comments. We have a medium which is malleable. It is evolvable. So if we want to talk about sharing of information, and we want to talk about a broad palette of ways in which that information can be shared, and a broad vocabulary for the creators of that information to express the terms and conditions under which they wish to share. The current medium does not solve all the problems. That's why we're having this debate. But if we wanted to describe the features and set to the engineers the task of creating those features, we could at least look at the consequences of that and ask whether it satisfies a broader range of sharing options than we have today, rather than fighting over old models that were based on older technology that don't have the same properties.
Thank you. Werner Staub.
My name is Werner Staub. I have a comment about the externalities associated with the payment for copyright and the externalities associated in the inverse situation where we have alternative sources of revenue. In the case of payment for copyright, of course, the people being sued for having downloaded, that's also one form of externality. But it's not the one that in my life I feel most. The one that I feel most here is not being able to find the content that I would be ready to pay for, and not being able to give to somebody the content that I would like to give as a present and pay for it. Simply because the laws and systems that have been put in place do not allow it. For instance, in many cases, we are not able to find the original forms of movies in English or other languages, because we're told that in this country the only way you get it is the dubbed version. Something that we suffer quite a bit from in Switzerland. But it's also other forms of censorship that just are actually implicit and not intentional. So this is somehow related to what Vint said. The terms of conditions under which a creator wants to make things available are not actually up to the creator, but the creator had nothing to do with these restrictions and did not intend them to be there. So I think it's just one example where we have to work on the mechanisms available to the creators and their representatives to enable the use of the content. There's another form of censorship associated with that, because there are many additional creators out there all over the place who would want to use a given work of art to add something to it, something very useful to it. For instance, every good movie would have many critics, would have language teachers, literature teachers would like to add something, possibly put in subtitles, possibly putting viewing capabilities that are associated with courses, and usually they're prevented from doing that because we don't have the systems up to the task. Now, we can say, on the other hand, we have the free alternative distribution models. YouTube is a very good example, where I see sometimes movies that I thought to be impossible to find, and I find them on YouTube, possibly in some form of violation of copyright, but it's still there on YouTube. Maybe a 50-year-old movie, the copyright holder did not do anything against it, maybe because the copyright holder preferred it to be at least visible and to have some statistics about it. There are also externalities associated with it because we don't know what happens with the social network information associated with viewers, but still I think there is useful information coming through those channels, and it may be one of the routes to achieving an infrastructure of information and identification and database resources that might help copyright holders and creators to develop these new channels of terms of conditions that Vint referred to.
Okay, first Nick, and then we have some replies from the panel again.
Yes, I'm Nick Ashton-Hart with the Computer and Communications Industry Association. I have a past as a featured artist manager, and I actually set up networks when I was much younger. So I actually have a background in policy advocacy for music, actual selling of music, and technology. Which may or may not have produced schizophrenia. But I have a question, but in order to ask it, a couple of observations come to me. Firstly, I believe that culture has value. Some of it has more value to some people than others, but all of it has a value, and anything that has a value, people are willing to buy. The question is, how do you make it easy for people to buy what they are interested in and access it in a way that is easy and convenient for them? And I think the unfortunate truth is that the music world was built around a model of scarcity. You could only really sell what you could put on the shelf. And the same is true for books. And the result is, with the internet, it's not a model of scarcity, it's a model of abundance. So we have a model in which you have to manually go and negotiate a license on a country-by-country basis with multiple rights holders for the same piece of music again and again. And I can tell you, this guarantees that most music will never be bothered with, and most countries will never be bothered with, because there won't be a perceived economic value to hiring more lawyers to go and do all those deals. It just won't. And so I think there's no way around having an authoritative source of information on who owns what. And once you have that, it's then possible to automate many types of uses that you cannot otherwise automate. And the truth is, if we really want more money to flow through to rights holders of all kinds, we have to make the licensing activity a far less expensive and time-consuming part of the monetization process. I'm not talking about making music cheap. I'm talking about making licensing of it cheap and automated, or you're just never going to get an abundance-based system to return value. And I think it's interesting, the other problem I think you have to deal with is right now the default is no. You can't use a right unless every rights holder in that piece of music, which can be dozens, says you can do whatever it is that you want to do. This is just not workable in an electronic world. I would say that there's a reason why the first all-you-can-have subscription service in the world started in Denmark. And it's because the rights holders in Denmark had a licensing model where the default was yes. For normal exploitation, you can use any piece of music ever produced anywhere. You pay the central bodies for it, and it gets distributed to wherever it needs to go. And so I'd be particularly interested in David and Martyn's views on this. If we had a system where normal exploitation allowed you just to pay and let some intermediaries figure out who to distribute it to, would that really be a problematic result? Because I think you'd get a lot more services as a result if you did that.
Okay, thank you, Nick. Unfortunately, Jānis Karklinš has to leave us. He has to give a speech in the European Parliament later this afternoon. So, and probably he will raise also some issues which we have raised here, because at the end of the day, parliamentarians have to adopt some laws if we want to get a real framework. So, two interesting questions. Who wants to reply first? Vint, David, and yeah. Okay, we have now 4 or 5 responses.
So I would like to endorse the proposition. For one thing, looking at this from the YouTube point of view, we can't tell that something that's uploaded has any rights associated with it unless we have some clues, and so registration processes have been very helpful. Discovering who owns what rights is very difficult, especially in a world where books, for example, are out of print, and sometimes you can never figure this out. And even though one of the Berne Convention said, it's yours, you don't have to register it, it's guaranteed, if we really are trying to provide the creators with an opportunity to express their wishes, that has to be registered in a way that's easy to discover. And I think this removal of friction, which is the way I interpret your comments, is clearly a good thing to explore because we have the power of automation at our disposal. So I am very much in favor of trying to pursue your idea.
David.
So I understand Nick's comments, and they're valid. The recorded music industry has tried very hard. At Sony Music, for example, when we negotiated licenses, we negotiated global licenses for whatever rights we had, because it just did not make sense to try to. But you know, the major music companies at least have licensed about 800 digital service providers to basically be music retailers on the internet. And there's a lot of them. And I guess most of them have about 7 million tracks. iTunes is now about 20 million. But I think that it is a problem, and I don't know where we start, if we start with registration. YouTube is a good model. The de facto registration for YouTube is that the recorded music owners put their song into the Audible Magic or some other fingerprint database. And then what happens is YouTube sees it, and regardless of who uploaded it, when it's played, they pay. I don't know if that's universally scalable, that kind of model, but I understand what you mean. I think the real problem is that people who want to implement a new or different kind of business model have to go back and renegotiate. And as somebody said, it gets very complicated, especially when you have the sound recording rights and the publishing rights. I don't know if this is easy to solve, but one of the things that Vint and I had talked about, Leslie and I have talked about in the past, is to start at the creation. And as I said, I'm actually a big fan of Creative Commons. I think what we really need is an expanded version of Creative Commons. Everything from the pure amateur to the professional creator should be able to indicate what they are expecting in some kind of machine-readable form. And so some people may be familiar with ACAP, which came out of the publishing industry. It was never really adopted, but the ideas are there, and I think that's the kind of thing that this group should be talking about to, as you said, to reduce the friction. There are ways, but we have hundreds of years of copyright history that do not make this easy, unfortunately.
Okay, Martyn.
To put it in a nutshell, I think we just need to shorten the route between the artist and the consumer. And that's going to mean some pain for the intermediaries that have been around for many, many years, ranging from publishing companies to agencies that have been designed to get in the loop where money flows. If we can find some universal registration mechanism, which technologically should be achievable, then this is going to mean that quite a few people are going to be out of jobs. But more of the there'll be more money generated, and more of that money will get to the creators. And I think also it will encourage more positivity and creation in the whole kind of ecosystem, if you like. And I love the idea of the default yes that Nick suggested. I think it'll make things a lot easier. I mean, I create a lot of things that I create new works that are based on existing works, and it's an impenetrable task. I'd have to have a full-time lawyer, or I'd have to abandon it all. Or the third way for me is I just get on with it and let the legal entities look at the outcome. And if they decide, if they issue a cease and desist order, then I probably would cease and desist. But I've never had one yet. So I would like to make sure that all those people I create compound works from get paid adequately. But it's incredibly difficult and time-consuming and costly at the moment.
Okay, Robin.
Thank you. Yeah, I wanted to go back to the point from the gentleman from ISOC Australia, and this idea of shifting the liability to third parties for infringing acts of others, and how that's a dangerous path to go down, but it's also a path that we're seeing the entertainment industry really pushing towards. This creates an enormous burden on these intermediaries to police and control their systems, and it shifts the costs over to them. And the net result of that is it's a business model which was going to require surveillance of consumers. And perhaps business models that are going to require surveillance are not the best way forward. This is shifting the costs of enforcement of the private interests to others. So we're also seeing a ratcheting up of enforcement rights, increasing the criminal penalties. New law enforcement agencies are being created out of taxpayer dollars to protect these private profits. So again, the profits are going to private interests, but all of the costs are shifted to the public to enforce those rights. And I think that's the wrong path to go down.
What I see here is also a very complicated and dangerous side effect. You know, if we introduce mechanisms to protect commercial interests like surveillance or things like that, the same mechanisms can be used also, you know, to protect political interests. And so that means at the end we end up, you know, with a system which is not anymore an open and free internet, and will be a censored, a renationalized, controlled, surveilled internet. And I think nobody wants to have this. Even the industry do not want to have this. So that means we have to live with some of these tensions and have to figure out, you know, what could be, let's say, the middle of the road, the third way or whatever. So we have now a problem. So we have 6 minutes left, and I have 5 questions. So either we add 5 or 10 minutes more to the debate, and, you know, people who have to leave from the podium, have to go. Yeah, so then probably they have to go. But my proposal is now that all the 5 people now on the list have 30 seconds to formulate just, you know, one concrete question, and then we will see, you know, how long we can continue with the debate. So, and I'm very strict now with the 30 seconds. Ricardo, from ISOC Venezuela.
Good morning. I will speak Spanish if it doesn't matter to you. Buenos días. Me preocupa mucho, con la excepción de Leslie y Daigle, que muy pocos hemos hablado de innovación y desarrollo en sistemas, en TI. Estamos siendo de alguna forma chantajeados por la industria de la música y el video. Y no son los únicos afectados con la Internet. Y no estamos hablando de cómo innovar para crear el nuevo Twitter o el nuevo Facebook o el nuevo Google. Estamos siendo chantajeados y es lo mismo que pudieron haber dicho casi todas las tiendas del mundo cuando nació Amazon. O cualquier agencia de aerolínea cuando nacieron los e-tickets.
Okay, I think it's clear. Your message is clear. I ask now, and Leslie will certainly reply, Eric Berger.
Hi, Eric Berger, and I'm glad Ricardo did that because I've got sort of the opposite. We've heard a lot of ideas about business models. We've talked about micropayments, we've talked about adware, shareware, collectives, a return to patronage like Slim's pay for the next song. We've talked about subscriptions where we know the industry makes more than it makes today. We've talked about how the industry's moved to licensing, not purchasing. I would offer that it's really all about the laws. As long as the laws are reasonable, in a sense, what right do we have to dictate to the music industry? What right do we have to dictate to the artists? What right does the industry have to dictate to us what the business models are? I would offer, as long as the laws are reasonable, let the dinosaurs die.
Okay. The right to dictate, this is a very good concept. Nigel Hickson from ICANN.
Yes, thank you very much. The question I had really was to take the debate a bit further afield. I know it's a debate on copyright, so I expect we better stay with that. But I was wondering what the panel thought of the use of if you like, this debate, and particularly the enforcement of copyright, the use of the enforcement debate on copyright to, if you like, look at other types of censorship of content across the net, and how various governments, if you like, use the need to enforce copyright, or the perceived need to enforce copyright as a way of controlling other content as well. Thank you.
Okay, thank you. Olivier Crépin-Leblanc, ISOC England.
Thanks very much, Wolfgang. I'm here. I'm going to speak just on my behalf and make it very quick, actually. Copyright is, I'm afraid, dead, and it became dead the day we went digital. Because before, when everything was analog, there was a natural barrier to being able to copy things with a degradation in quality. Now that we're all in a digital world, it can be copied ad infinitum. And so with a USB key that I have in my hand over here, I can pass it to whoever it is around and pass on the information that's in there, including music, including everything else. So new business models really appear to be the only solution, unfortunately, and it's going to be a really, really hard ride. You have to work with buzz marketing, you have to work with trying to do viral marketing, find ways. I've seen some really, really incredible ways from new companies that come out there that do this. Why do Apple have to come up with iTunes when the music industry could have come up with something equally as good and probably even better? There's some really brainy people in the industry. So.
Actually, we couldn't because of antitrust laws in the United States and Europe.
And the last on my list is Brewster Kahle from Internet Archive in the United States of America.
Thank you. Many have said that not everything should be copyrighted. Do we really have a problem with the defaults that are buried in our laws? When I was growing up, you had to put a C on things and send a copy to the Library of Congress. Otherwise, it was open. Open was default. This changed in 1976, and we seem to have come into real problems on the internet. Do we really basically have a problem that we've made the default wrong and conflict with common sense?
Okay, now we have 30 seconds for each of the panelists. I go from the left side. Leon?
Well, maybe yes, the default may be not right now. And the question here that I would like to raise to the technical ones, not the legal ones. From the legal point of view, we know what we don't need to do. There are clear examples as ACTA, as SOPA, as PIPA, and other laws that haven't passed and shouldn't be passed. We know how not to do it from the legal point of view. How can we answer this question to protect everyone's rights? And I mean everyone's, even the industries. How can we manage to do this without harming the internet, without chilling innovation, without letting all the creators out of an economical benefit? This is the question that I want to leave to everyone here, and the technical community should help us to answer this question, which is the mechanism that may effectively enforce and protect intellectual property rights while preserving access to knowledge, access to information, freedom of speech, and due process. Thank you.
David, what is your final point?
Well, I think my final point, and I'll pick up on Eric's point about let the dinosaurs die. I think that the content creators should be able to indicate how they want their content to be used. And if they indicate it in such a way that there is no legitimate market for that, then they should just not get the revenue. They should be encouraged by the marketplace to offer it in a way that people want it. And, you know, we do have millions of people who are quite happy with the business models that are being offered. And then we have people who prefer to not pay. But I think if we start with the content creators, and there is a way, especially with technology, I keep coming back to ACAP and some other ways, so that the will, the wishes of the creator can flow through the system. Then if I decide to be super restrictive with my song and nobody buys it, that's my fault.
Leslie.
Thank you. Going back to the question of innovation, I think that the things that we need to do are respect laws and to ensure that we have an orderly society across the globe, focus on building blocks, both in terms of technology and the laws, not presupposing outcomes, but rather the building blocks to build that which will work. Recognize that incumbents are unlikely to innovate, they have little motivation to, and therefore we need to empower end users in order to get that innovation while respecting laws.
Okay, Vint.
I think I'm happy with what Leslie said. I do think we have a big opportunity here. We have a very, very flexible system in which we can create a variety of ways of managing information. Let's not get totally focused on internet, by the way. The point about digital information is very important. It's the fact that it's digital that makes it so easy to share and distribute and reproduce and everything else. We have to create a new ecosystem which makes sense in the digital world to satisfy a very broad range of desires of the creators of that content.
Robin.
Thank you. Yeah, also would like to pick up on this notion of innovation, because I do think that is the way forward for artists and other creators, is to be willing to experiment, try new business models. You know, don't be afraid and to fail. And if you do, learn from that, what happened, go back and retool and move forward. At the end of the day, I think the internet will ultimately create a world where there is much more art, much more culture, much more learning and knowledge. And so let's not try to stifle that and chill that great possibility in order to protect this one discrete, outdated business model. Thank you.
Martyn.
Okay, where do we start?
1 point only.
Okay. Positivity. We have to be positive about the way that we can use new techniques to create new collaborations, new forms of creativity, and then we need to facilitate the shortening of the route from the creator to the end user, and we need to be able to find a way that the creators can get compensated should they so require. It's completely wrong to think that it's a misconception that the old models are the unrealistic way of making money. Is complete nonsense. Thank you.
Okay, thank you.
Okay, I want to raise a new point. That is, some copyright industries' regional marketing strategy is actually preventing the availability of work in certain geographical region. The blockbuster from Hollywood is not available legally in Asia until a few months later. And because it's the internet age, everything is transferring, communicating simultaneously. The unlicensed copy were available when the authorized copy was not made available to that market. So this is a big issue. I want to go back to Nick's point, whether we need a general compulsory licensing regime, make a default, yes, and really fundamentally reform copyright from exclusive right to remuneration rights. If it's only the issue of rewarding the creator, they don't need to make it the consent every time when the work is used. Okay.
Thank you, Sacha. It was not my plan to give WIPO the last word, but
I'll use it judiciously. So on a positive note, I don't think we're far away from a good outcome here. I have always thought that if ISPs are able to offer, €5, €10, all-you-can-eat kind of subscription plans to movies, films, etc., and if you then use intelligent registration system, NICs, and payment system that back those up, that we will end up with an amazingly larger pie. I mean, music industry revenues are relatively small if you compare it to telecom revenues, etc., all these sort of things. So you can end up with a fantastically large pie, plus that gets distributed in a much more efficient way than it ever was.
So let's wait for the growing pie. We started 7 minutes late. We are 7 minutes over time, so more or less we did what we could do. I think there is no way to summarize all this. We had all kinds of words here: ethics, fairness, transparencies, layers embedded in technology, complexity, registration mechanism, right to dictate, flexibility, creativity, censorship, new ecosystem. It's growing. But I think Robin made a very good statement by saying, don't be afraid. Don't be afraid to fail. So this is innovation. We enter a new territory and we have to discover this, to explore what's going on. And in 5-10 years, probably we will know more. We will know more than we know today, and it's the only way forward. So do not fight the battles of yesterday. We are in the 21st century. We have to. We all sit in the same boat, so we have to work together. Collaboration, as Vint always said, this is the secret of the success of the internet. And if we want to make the intellectual property system successful, then it needs a multi-stakeholder collaboration. Thank you very much, and enjoy your lunch.